Thank you. Thank you. Oh, please sit down.
Hello, everybody. We're a little bit late because Justice Ginsburg actually has a day job, and she actually got a call and needed to be involved in it. But we are thrilled beyond words that you are here. I don't need to really spend much time on the introduction. I don't think I will. I will say this, that there are very few people who have ever been appointed to the United States Supreme Court whose career beforehand were as distinguished as the career afterwards. And that is true of Justice Ruth Bader Ginsburg. I also just want to say personally that I had the great privilege of getting to know Justice Ginsburg a little bit when she first joined the Court of Appeals in Washington, D.C. And a few years later, I got a call from Justice Ginsburg saying, "Are you a member of the ABA?" And I said, "Yeah." She said, "Well, then I'm going to support you for something." And she has done that for me, as she has done for so many others. So a whole other story about Justice Ginsburg is her mentorship, particularly of women. And for that, I am very deeply and personally grateful. On the wall of her chambers is a sign that says, "Justice, justice, thou shalt pursue," the Old Testament words. And we're going to pursue, actually, a little bit of your autobiography, but some justice might appear as well. Justice Ginsburg, you grew up in Brooklyn, New York. And it was a community of poor working class people. Is it true that you were involved in a twirling squad? What are your, what are your memories of your time there?
Yes, Martha, it is true that I was a twirler at James Madison High School. And what that meant is that we had to perform at every football game.
Oh, wow.
I learned to hate football as a result of freezing. But I marched in a few parades in the city, and that was fun.
Some people remembered you as a very popular student and also as a very brilliant student. And it's true, I think, isn't it, that your mother gave you some advice, who you sadly lost before your graduation. She said something like, you should be a lady, but you should also be independent. Is
Yes.
that right? And so was the idea of having a career something you had in your mind when you went off to college?
Yes, I was going to be a high school history teacher.
Huh.
I had no aspirations then to be a lawyer because women couldn't make a living practicing law, but teaching was a field where women were accepted and there was a nice, steady income. So yes, I was going to be independent. And what my mother meant by be a lady was not to be haughty, but a lady doesn't get disturbed by things that maybe are off-putting. She reacts calmly without anger, and she has nothing to do with an emotion that's terribly draining on your time and you can't do anything about, and that's jealousy. So that's what being a lady meant, being calm and not letting things affect you adversely.
This might be a useful quality in your current job.
No, but better than that is the advice my mother-in-law gave me the day I was married. I was married in my husband's home, and just before the ceremony, my mother-in-law sat me down and she said, "I have some advice for you about what makes a happy marriage." And she said, "Dear, sometimes it helps to be a little deaf." and with that, she handed me a package of Max earplugs that I use to this day. It turned out to be wonderful advice not simply for dealing with my spouse, but with my colleagues on law faculties and now on the court as well. It helps sometimes to be a little deaf.
I am going to copy that. You went on to Cornell University with a scholarship. What were the highlights there?
Well, Cornell was a place for girls to go because there were 4 men to every woman. So if you were the mother of a daughter, that's where you sent your daughter if you could, because she could find her man within the 4 years. And we never questioned that. You know, the other thing about life at Cornell was that the girls had to sign in. So we had to be back in the dorm by 10 on weekdays, 12 on Friday, and 1 on Saturday. That was
wow.
And if you didn't get back in time, you were literally locked out on the street.
That didn't happen to you.
It did once.
You did happen to meet an amazing individual, Marty Ginsburg. It was a blind date, is that correct?
Well, not exactly on his side. No, Martha, this is how it came about. Marty had a girlfriend at Smith, and I had a boyfriend at Columbia Law School. Friends of ours thought it would be nice, and Ithaca can get pretty cold during the week. If we spent time together, go to the movies, and besides, my friend was dating Marty's roommate, and Marty had a gray Chevrolet. so that's how it started. And then the remarkable thing was Marty cared that I had a brain. You know, most guys really were not interested in whether a girl could think. So that was a whole new and wonderful thing for me. And we were best friends for a full year before we were more than that.
Wow. Then he had the idea of going to Harvard Law School, and you were still at Cornell, and then he was drafted. And that's pretty complicated.
Well, he wasn't exactly drafted. He was called, he was in the reserves.
In the reserve, I see,
Because,
so called up.
And that came about at Cornell, the first 2 years, I don't know what they call it these days, but it was ROTC, the Reserve Office.
Mm-hmm.
So the first 2 years were compulsory, then in the 3rd year, it was elective. And when Marty was asked, did he want to go to senior ROTC, he wrote, "Hell no." And then the Korean War.
Oh,
So all things considered, it was better to go in as an officer.
sure.
So he had to get back in. Anyway, he was taken out at the end of his first year in law school. Oh, I should mention something about this place. My idea was that Marty and I would be in the same class. So I would leave Cornell at the end of my junior year, and I would transfer to the law school. Yeah. I would take my 4th year of college at Cornell Law School, and then come here and join Marty in the 2nd year class. When I asked the powers that be, could I do that? And they said, it's fine if you want to take the 1st year of law school at Cornell, but we will give you no credit for it. So the idea of 2 first-year law schools was not very appealing. Instead, I had the best year I ever had in college. I took only art and music courses.
Wow, wow. That does sound pretty spectacular. You did enroll in the law school here. It was unusual. There were not very many women going to law school. There were 9 in your class, is
Yes.
that right? And Harvard Law School was not particularly welcoming to women. Is that right? These are leading questions.
Well, one example of not being particularly welcoming, I had come from Cornell, where the girls had to live in dormitories. The excuse for the 4-to-1 ratio is the girls have to live in dormitories. The boys can find places in College Town. I get to the Harvard Law School, and there's no room in the dorm for the girls. The girls have to find a place. Because it didn't affect me, because by that time I was married and had a child. But that was Harvard's attitude. The women, we will take them, but they have to find housing for themselves.
Well, you did excel here despite the atmosphere. You earned a position on the Law Review. Is Law Review good training? Was it worth doing?
I think I learned more from my classmates on the Law Review. Unlike some of my classmates, I did go to class. But that was a great experience.
Mm-hmm. Do you read law reviews now? It's okay, you won't hurt our feelings.
I don't read law reviews from cover to cover. I do read occasional articles.
You have made some people very happy just now. That's wonderful. You did
I do read the Supreme Court note.
The issue of a review of the court.
Yeah.
You did attend school while you were married and a mother, and also Marty became ill. And you attended class for him? Did you take notes for him?
No, people have said I attended his classes. I didn't. I had note takers. These were long before computers, so classmates would put carbon paper,
yes,
and I would get the notes. And that's why that was Marty's third year, my second, why I have such genuine affection for this place, because our classmates, both his class, and this was supposed to be a fiercely competitive place, the help that we got from our friends here, I will remember all the days of my life. One of them knew that I had quite a lot on my hands, so he had his girlfriend type the notes.
Wow.
They came to, Marty had the best teachers. He had tutorials, first in the hospital and then at home. He attended 2 weeks of the spring semester, and he got the best grades that he ever got because he was taught by his classmates.
Wow. Wow. Then we come to the part of the story that I've heard you tell, and it's fine to tell it. Marty recovered wonderfully and graduated and took a job in New York, and you came to the dean of the Harvard Law School with a proposition.
I said, if I successfully complete my law school at Columbia, will I have a Harvard degree? And the answer was, absolutely no. You have to stay the third year. And then I thought, the perfect rebuttal argument. There was Mrs. Isselbacher, who had transferred from Penn. She'd gone to Penn for her first year, transferred to Harvard for her second and third year. The first year is supposed to be by far the most important. I had year 1 and 2. She would have year 2 and 3. Mm-hmm. So I thought it was
comparable.
Yeah.
Yes? But no.
No.
So Dean Griswold's decision led you to transfer to Columbia Law School, where you promptly made law review and became the top of the class. And deans ever since have said, could you please accept a degree from the Harvard Law School? And your answer, I think, has been no. Until you received an honorary doctorate of laws in 2011 in the good company of Placido Domingo. How would you assess your relationship then with the Harvard Law School?
Well, one on having a Harvard Law School degree, which your predecessor offered me every year. You can't rewrite history. That's the way it was. But, and one thing that Marty said when Elena would call and say, we would love you to have a Harvard degree, he said, hold out for an honorary degree, which I got a year and a half ago. So
that was worth it.
But the hardest thing for me was going to Columbia, wondering whether I would end up with 3 years of law school and no degree from any school. So I never asked the question. I was glad that Columbia accepted me as a third-year student. And then I received a degree from Columbia Law School, and I got this credential that when I go abroad, or at least it used to be, that this was spectacular, that this is a woman who was on the Harvard Law Review and the Columbia Law Review. They didn't understand that these were student journals.
It's still very impressive. But it was, yes.
This is, I'm sorry, but there's an emergency, so Martha,
please.
I'll be back
yes,
in
of
just.
course.
I think we won't have another interruption. I'm not 100% sure, but I think so.
Does this happen often?
It happens regularly in death cases when we treat them like a firing squad. All of us have to vote on the final petition. So sometimes, wherever we are in the world, but this one is a case from my circuit. Each of us is responsible for a circuit. Mine is the Second Circuit. So if any emergency applications come up from the Second Circuit, then I will be the justice to respond.
The wonders of modern technology. It is, unfortunately, the fact that when you graduated from law school, it wasn't easy for you to get a job. Professor Al Sachs here recommended you for a clerkship for Justice Felix Frankfurter, who did not interview you. And no law firm offered you a job. A few years ago, you told an audience that if a law firm had offered you a job, today you might be a retired law firm partner. So that's a classic, making lemonade out of lemons. So what did you do?
Well, I had a wonderful teacher at Columbia, Gerald Gunther, who later went to Stanford, and he was in charge of getting clerkships for Columbia students. He took me on as a very special case, and he called every justice on every judge on the Second Circuit, every judge in the Eastern District and Southern District. There was one, Judge Palmieri, who always took his clerks from Columbia. He was a Columbia graduate of the college and the law school. Judge Palmieri hesitated. He said, but she has a young child, and sometimes my clerks has to come in on a weekend. So this I didn't find out till years later, but Jerry said he offered Judge Palmieri this choice. Give her a chance, and if she doesn't work out, there's a young man in her class who is going to a downtown firm and will take over.
My goodness.
So that was the carrot. And then the stick was, if you don't give her a chance, I will never recommend another Columbia student to you. Wow. So with that, I got my, my clerkship.
Wow, that's amazing.
With the law firms, it was, first of all, this was pre-Title VII days. So many of the firms that interviewed at Columbia had sign-up sheets, and they would say men only. It was hard enough to get a job if you were a woman, but if you were a mother, that was, then it was impossible. Right. But once I had the clerkship with Palmieri, and he was able to tell people, even on a Sunday, if I need her, she's here. Then I could get a job with a law firm, and to my great good fortune, I didn't. Instead, I went off to do this project in Sweden for 2 years.
It is remarkable, because you did have at that point several offers, right? But
Yes.
you went to work on international procedure, and you learned Swedish?
Then it's Justice O'Connor tells the same story. You know, she graduated a few years before I did, at the top of her class, and there was no offer. So she volunteered to work for a county attorney for 4 months with no pay. And the understanding was that if she did a good job,
Wow.
then they would put her on the payroll.
Well, your project on international procedure, of course, is very meaningful to me as a procedure teacher. Were you thinking then you might become an academic, or you didn't know what you would do at that point?
I thought I would become, I wanted to end up teaching, but not immediately. I wanted to practice for 5 or 6 years first.
One of the things that's very fascinating about your jurisprudence is your openness to international and comparative sources. And I wonder, does that relate to this early experience with comparative procedure, or did that develop otherwise?
It very much related to that. I think I learned more about my own system from seeing how another system treated similar projects. And I have to say that another influence was probably the best teacher I ever had any place, with the possible exception of Nabokov at Cornell. It was Benjamin Kaplan. I had him for procedure. He was the first teacher that I encountered in this law school. I loved his class, and you probably know, Martha, that Ben, with Arthur von Maren and I think a German collaborator, did this two-set piece on German civil procedure.
Classic, yes. Absolutely extraordinary. And Ben Kaplan, who went on to be on our high court in Massachusetts, continued to be a backbone of procedure teaching even when I joined the faculty. You did become a professor, first at Rutgers, then at Columbia. You did publish a book, Civil Procedure, in Sweden in 1965. But you also started to work on issues of gender equality. And the New Jersey affiliate of the American Civil Liberties Union became a place where you did some work. The Women's Rights Project at the ACLU in 1972 became your bailiwick. Did you have a conception of a strategy, or what led you to turn to sex discrimination?
My students and women who were making complaints that they never made before. It was both sources. It was the students wanted a course on women and the law. And to prepare for that, I read every federal case from the beginning of time on bearing on gender discrimination. That was no difficult chore because there was hardly anything. I mean, I think now, inside of a month, there would be more than there was in all that. Then the ACLU in New Jersey was beginning to get complaints from women, mostly teachers. And their complaint was, the school says we must leave the moment we begin to show that our pregnancy. And they call it maternity leave, but what it means is you are forced out of the classroom at the 4th month, the 5th month, and the leave is without pay. You have no guaranteed right to return. If they want you, they will call you. So it was those pregnancy discrimination cases. And another type of case a woman who, say, this one worked at the Lipton tea plant, her workplace had a good health insurance package. Her husband's did not. So she wanted to get family coverage from her employer. Family coverage was available only to male workers, not female. So that was another.
Wow.
Those. And then there was Princeton. Princeton had a summer and engineering program designed to take children from poor communities, introduce them to math and science at an early age. It was a great program. Just one thing wrong with it. It was for boys and not girls. So those were the kinds of cases that I wasn't looking for them, but when they were there, I thought, what a tremendous opportunity for me.
Did you think that the experience that led up to Brown versus Board of Education offered an analogy, or that a litigation strategy could be successful on gender issues?
Yes, well, we were frankly copied what the NAACP Inc. Fund had done. That is, not to take the court by storm, but to lead them there in slow degrees.
Step by step.
And that's what we did in a series of cases litigated in the 1970s.
Well, and brilliantly done. You said that what you wanted to do was open the doors for men and women. And one thing that I think isn't always well known about your strategy and your approach to this is that you were really addressing the constraints that gender roles play in the lives of both men and women. Is that right?
Yes, and I think it's best encapsulated by, was it Marlo Thomas?
Marlo Thomas, yes.
Marlo Thomas had it was a song.
Yes.
And the title was Free to Be You and Me. So that was the idea. So if you were a man and you wanted to be a nurse, that was fine. And if you were a woman and you wanted to be a rocket scientist, that was fine too.
There was a recent decision to allow women into combat. And that was an issue you addressed a long time ago. But it didn't, or even women in the military. And as I recall, the question initially was a man who said, why should men be drafted and not women?
Yes, I was not involved in that. Was the Rosker case.
That became Rosker,
and I was already on the D.C. circuit.
At the D.C. circuit when it was decided, absolutely.
At that time, it came to the court too soon.
Right, right,
Yeah.
right. You were appointed to the Court of Appeals in 1980, and you, from the start, you established a reputation as being precise, hardworking, absolutely on top of everything, balanced opinions, and that's continued ever since, also known for your courage. And then appointed to the United States Supreme Court in 1993 to succeed Justice Byron White. And President Clinton described your life story when you were appointed. Did you think that becoming then the second woman on the United States Supreme Court, that would be it? There would only be 2 women on the court at a time?
First, let me say that 2 is my lucky number. I was the second woman hired at Rutgers Law School, second woman on the D.C. circuit. I fully expected that we would have 3, 4, maybe more. Now we have 3, but the Supreme Court of Canada, our neighbor to the north, has 4 out of 9, and the Chief Justice is a woman.
And there's some state Supreme Courts that have a majority of women.
Yes, there was one state Supreme Court that had only women for
briefly.
a time. Yeah.
Yes. Many court watchers are very impressed by your expertise in procedure. I'm one of those, personal jurisdiction and airy. But also, many comment on your expertise in economic and quantitative analysis, that you are alert to that and you're alert to the impact of law in the lives of people and communities. Is that something that you're mindful of, or it just happens in response to the cases and the briefs?
Well, law exists to serve the society, so how can you not think about what is the impact on people of the court's decisions?
Everybody hear that? Your court is known as a collegial court, and you are also known as one of the people who helps to make that happen. How do you make that happen?
In the many years that Marty was with me, one of the ways was he was a fabulous cook, and for every justice's birthday, he would make a cake.
Oh, wow.
For the spouses' quarterly meetings, he was the chief caterer. What do? I have no talent at the kitchen at all. But we have, now at the court, we have twice a term, once in November and the other in May, a musicale, where all the justices and their friends come and take time out of their time away from the briefs just to listen to beautiful music. That will help. So,
you actually, as a group, you engage in a ritual before is it before you sit on the bench of handshaking and putting on your robes? You do that?
Yes. It's before every conference and before we go on the bench, either in the conference room or in the robing room. We shake hands with each other. And you look your colleague in the eye and think to yourself, even though he wrote that nasty dissent, we're all in this together, and we do revere the institution for which we work.
When Chief Justice Rehnquist donned a robe with gold stripes on it, many people wondered why. And you had a theory why he did that.
It wasn't just a theory. I knew why. There had been, that summer, a low-budget production of Gilbert and Sullivan's Iolanthe. A major character is the Lord Chancellor. The costume for this Lord Chancellor in the summer production had a robe with 4 thin gold stripes. Now, the real Lord Chancellor has 4 stripes, but they are broad and brocade, very splendid. The chief copied the summer theater costume rather than the real Lord Chancellor. And when he was asked, why did you do this? He said, I didn't want to be upstaged by the women. And by that he meant, Sandra wore very often a British collar, and I had a variety of collars.
So there may be competition among you and your colleagues. And again, with this collegiality, I mean, last year you had some pretty divisive opinions. This year you may again. Do you think that there's a jeopardy that you won't remain as collegial?
There is. There's always that danger, and I sometimes cross my fingers and hope that we will not have a major rift. So far it hasn't happened. Didn't happen with Bush v. Gore. Didn't happen last term with healthcare. Didn't happen with Lilly Ledbetter.
Right.
So I hope that we will maintain that. That really, it's more than tolerance. We genuinely care about each other. And I saw that personally through my 2 cancer bouts while I was on the court.
You mentioned Lilly Ledbetter, and in a minute I'm going to invite you all to share some of the questions that you all talked with each other. In that instance, when the court reached its decision, you actually spoke from the bench from your dissent. That's not something that's very common. When would you choose to do such a thing, and why did you choose to do that?
No more, most cases, I think most years I haven't read any dissent from the bench, but one year I read 2. I think it was a Lilly Ledbetter and a Carhart.
Yes, Carhart. Mm-hmm.
Because I wanted people to realize that what the court had done was not merely wrong, but egregiously so.
I think people listened.
So Congress listened with Lilly Ledbetter. Yeah.
Yes. So if you have questions, come up to the microphone. I'm going to ask one more while people are doing that. Is anyone doing that? Yes. We're living in an era of 24/7 news. How does that affect the court? And is that a case for or against having cameras in the courtroom?
How does the daily news affect the court? There was a brilliant scholar at this law school, Paul Freund, who I think said it perfectly. He said, the court ought not to be affected by the weather of the day, but inevitably it will be affected by the climate of the era. And I think that's so. I think that explains why you had the, quote, conservative Berger court turning over statutes, state and federal, because they discriminated on the basis of gender, where it didn't happen in the Warren court. It was the climate of the era that explains those decisions. But the weather of the day should not.
So introduce yourself and ask your question.
Oh. Hi, my name is Lana. I'm a 1L here, and thank you, Justice Ginsburg, so much for coming to speak with us. My question for you is, I know you've spoken in the past that given your history with the ACLU and your other advocacy work, you don't think you would be able to be confirmed to the Supreme Court if you were nominated today. So my question is, what advice would you give to a lawyer starting out nowadays who was dedicated to spending their life in public service, but also wanted to be eligible one day to be a judge?
Well, have faith that we will return to the way it once was. I regard this as a temporary situation. I was nominated in 1993. The vote was 96-3 for Justice Breyer, who was nominated the next year. It was a similar vote in the 90s. The dean of this law school had something like 30 negative votes.
Correct. When
she was superbly qualified to be on the court. I hope that what we have seen in recent times is a temporary situation, and we will go back to a spirit of bipartisanship which prevailed in the early 90s.
That's true.
When the ranking Republican on the Judiciary Committee, Orrin Hatch, was my biggest booster. So I hope that it will be that way for you.
Thank you very much.
Thank you again. My name is Ezra. I'm also a 1L. I'm sure you can't talk about the call that you just took, but I'm curious, when you get calls like that, what goes through your head? You know, are you comforted by the fact that there's been a lot of process and you're just the last one in the line, or is there part of you that sort of feels like executioner?
Say it again at the very end.
How do you deal with getting a call where you know that someone's life is really at stake based on?
So when it's a death penalty case.
Yeah, this happened not to be a death penalty case. It's the only part of the court's business that I genuinely hate. I'd been on the D.C. circuit for 13 years with no death penalty, so this was all new to me. And the first time, it was really rough. The first time I voted in a death case, they tend to set executions at 2, 3 in the morning. I remember staying awake until after the execution and crying. But now it's something that I just have to do. I will never adjust to it. I'll never feel comfortable about it. I could have made the choice that Brennan and Marshall made. They took the position that the death penalty in any case was cruel and unusual. But if I did that, then I would be out of the running, and I couldn't influence the results in particular cases.
And sometimes you do. Thank you.
Hi, my name is Laura Wolf. I'm a 3L, and I'm wondering if you could, ignoring all precedent, all cases that have come today or to this day, change any one major factor of feminist legal jurisprudence or the law that affects women, what would you change and why?
If you were totally free, you have no colleagues, no precedents.
Yeah, what would you want to see for women, basically? What changes in the law would you want to see for women?
I think the changes that are left, the most important changes, can't be decreed by any court. The court has ended the closed-door era. It has held unconstitutional most express gender lines in the law. The discrimination that remains is more subtle, and it takes people who care about it. Well, I'll give you one example because you're all going to be lawyers. When our children were young, we decided that unless it was something really of major importance, we would have dinner together every night as a family. My husband worked for a large firm in New York where the practice was the associates stayed around the clock. Life didn't have to be that way. The tax department was one of the most successful departments, but everybody was out of the place. Everybody in that department was out of the place by 7. Some people today just think they have to conform to whatever is the mold instead of allying with other people who think like you to change whatever is the firm culture. So I think the big job is for you to say, there should be a family life, a home life, and a work life, and you should be able to do both successfully.
Well,
and by the way, he should be a parent. He will surely regret when his children are grown if he hasn't been part of their growing up.
Thank you.
and you certainly did this extraordinarily well. Your 2 children are wonderful people, wonderful parents themselves, and it certainly couldn't have happened without having a spouse who was involved the way that Marty was. But were there moments in juggling work and family where you thought, if only there was some other outside help, it would have made a difference? Or was it something you felt was for you two to work out?
It started in law school. Sometimes if the babysitter was not available, and I would then stay home and then appreciate how my life was with. I went to school and attended classes, and then I came home to this young child, and it was a respite from the law school work, and then the law school was a respite from taking care of my child. But it was staying home for a few days that convinced me that I wanted the balanced life and not exclusively one or the
other.
Or the other.
Great. Yes. Oh, sorry. Great.
I'm John. It's such a thrill to have you here. I'm wondering, to follow on to your last comment about the courts have done what they can in the area of women's rights, what the other areas are where you think the courts haven't done all that they can and could be doing more. And I know you can't comment on gay rights, but more broadly, where can the courts do more and where is it appropriate for the courts to do?
Well, the courts are institutions that don't lead. I mean, it's rare that a court will move unless the people want them to. So before every major change, the civil rights movement, it was people who saw that the laws were wrong, wanted them to change, were fighting first to capture other people's minds so that the movement would be large, and then try to get legislative change, and then the court is the last resort. But the idea that you go to the court and the court will fix it doesn't work, because it has to be the people who want the change. And without them, no change will be lasting.
Justice Ginsburg, my name is Andrew. I'm a 2L, and thank you for taking my question. I wonder, as you go through the briefs and listen to oral arguments and talk internally on the court, how often do you change your mind, or how often do your colleagues change your mind based on something you hear or some points that you might not have brought up compared to preconceived notions of an idea how the case might come out?
Do I change my mind as a result of the oral argument?
Or any of the other information that comes to light from the briefs or talking to the other justices?
Of course, the briefs and the arguments will influence your thinking. In the class I attended, I explained that in some cases, I have no idea what is the right answer, and I'll read one brief and find it persuasive. Then I'll read the answering brief and say, that's a good argument too. And then I try to read as much as I can other courts that have addressed the problem. Maybe a law review article that's digestible. I keep working at it and reading, talking to my law clerks, and then I think my son has just come. Then either a light will turn on or the trees, there'll be a path through them. So usually by the time I get to oral argument, I am comfortable leaning one way or the other in a case.
Great.
Hi, my name is Jordan. I'm a 2L. I took Professor Klarman's constitutional law class last semester. We talked a lot about backlash created by judicial decisions, especially in abortion and the death penalty and gay rights. And I was just curious whether you think that view is accurate, that court decisions can create a pretty large backlash, and whether other movements should be wary of creating that through the court system.
Well, I would hardly quarrel with my brilliant former clerk, Michael Klarman. But I don't think that the anti-abortion movement, that it was just Roe v. Wade. I mean, that movement existed before Roe v. Wade. It existed after. I do think that the way the court went about reaching its decision did give them a target that they could aim at that they didn't have before. But the court decision is hardly what created the movement. I should say that because I've been criticized for she's against Roe v. Wade. No, I'm not. I'm very much for the judgment that the court rendered, dealing with what was the most extreme law in the country, where a woman could get an abortion only if it was necessary to save her life. Could be disastrous for her health, and it wouldn't matter. The court easily could have said, we'll deal with the Texas law, that's what's before us. We'll declare that unconstitutional because it's much too far out in disregarding the situation of the woman. But we then put our pen down and we wait for the next case, which is how the court usually operates. This is an unusual judicial decision because it made every law in the country, even the most, quote, liberal, unconstitutional in one fell swoop. That's not the way the court ordinarily operates. So that was my critique, was not of the judgment, but of the giant step that the court took instead of proceeding by slow degrees.
Hi, Justice Ginsburg. My name is Caroline. I'm a 3L. You mentioned earlier that you took a number of arts and music classes in your last year at Cornell, and you're a well-known lover of opera. And I was just wondering that right now, when a liberal arts education is being strongly criticized, how you feel like your study of and interest in arts and music and literature has affected your life as a lawyer and a judge.
It has enriched my life. I couldn't imagine living without art and music. And I hope that all of you appreciate that too. I mean, living without music, living without art, would be a very sterile existence.
Not to mention, maybe you could even get colleagues with whom you disagree to have a common experience of enjoying the art and finding another way to relate to one another. That's powerful. Justice Ginsburg, we are honoring you today, though you honor us more than we can say. We wanted to honor, though, your 20 years thus far on the United States Supreme Court. I underscore the thus far part. And as a faculty, we thought about what we could do, and we thought about flowers. We could give you a dozen roses, and instead we decided to give you a dozen essays because that's what we know how to do. And so we have a dozen essays, each one about a case of yours, and I will now describe a sentence or two from each of these essays. I'm not going to read them all. And as I do so, I'll ask the authors if they're here to stand. And this is also a chance for everyone here to have a sense of the range of topics and issues that Justice Ginsburg has addressed and addressed so brilliantly. The first one is actually mine, and these are in order chronologically. I am not going to stand, but this is a 1996 decision in a case called MLB versus SLJ. Justice Ruth Bader Ginsburg's opinion in MLB versus SLJ, holding that a state may not deny an indigent parent the chance to appeal judicial termination of her parental rights by requiring payment to prepare the trial court record, is a work of great craftsmanship as well as a just and compassionate decision. You did say something to me about this opinion. I have to say it is remarkable that you had a court for this opinion. It is an enormous landmark decision that against a backdrop in which the court has not been in support of actually providing affirmative rights.
It all seems, in retrospect, so easy. This was a woman who was deprived of her parental rights. In order to appeal, she had to prepare a transcript. And she had no money to purchase the transcript. I think it cost something like $2,000.
Right, exactly. Incredible. Yes.
So she couldn't appeal because she couldn't buy a transcript. Well, if you were in the criminal justice system, even if it were a petty offense that had no jail time, the state paid for the transcript. You know, comparing the deprivation that a parent would feel when she was declared a non-parent to a petty offender who had to pay a fine. Didn't make any sense to say that the state provides a transcript for one, but not for the other. So it was that theme that helped to compare the deprivation and forget the labels of one is a civil proceeding and the other is a criminal. What does it really mean to the person?
In their lives, right?
Yeah.
The next decision and writer is Lee versus, is it Kemna? Kemna, 2002. Vicki Jackson is the author. And her essay says, this opinion invites the state court system to continue to develop and enforce procedural rules to assure the orderly conduct of trials, and trust them, appellate as well as trial judges, to apply those rules with sensitivity to the possibility that on rare occasions, an application will be so exorbitant that adherence to the procedural values of our constitutional judicial system should allow adjudication on the merits. Trusting the courts.
Thank you, Vicki.
Norfolk and Western Railway versus Ayers. The author is Richard Lazarus, 2003. Justice Ginsburg knows the court's cases are ultimately about people, their lives and their livelihoods, and she never loses sight of the fundamentally human aspect of the court's work.
Thank you, Richard.
Grutter versus Bollinger, 2003, Deborah Anker, not sure she's here. We academics and practitioners in the field of refugee law thank Justice Ginsburg for taking leadership in legitimizing the role of comparative and international law in our national context. Susan Farbstein also wrote about Grutter versus Bollinger, 2003, and said, American attorneys working on human rights issues, whether on the United States or abroad, find her willingness to consider the practices and logic of the international community especially valuable. Coons Buick Pontiac GMC Inc. versus Nye, 2004, John Manning. In this court, statutory interpretation is a lawyer's craft, and Justice Ginsburg is a lawyer's lawyer. She exemplifies the new legal process school, which wisely recognizes that Congress passes statutes to fulfill some purpose, but that the words it has selected may clearly express that purpose and its limits.
Thank you, John.
Then we get Ledbetter versus Goodyear Tire and Rubber Company, 2007, your dissenting opinion. Lonnie Guinier wrote about this. By speaking colloquially, using the personal pronoun you to address her audience, Justice Ginsburg signaled to ordinary women that the majority should not have the last word on the meaning of pay discrimination. Her goal was to engage an external audience in a conversation about our country's commitment to equal pay for equal work. That might have been about the oral dissent, is that right? Yes, it's about the one you read from the bench. Next is Gonzalez versus Carhart, also 2007, also a dissent, and Larry Tribe wrote about that, as well as Bays versus Rees, 2008, also a dissent. And Larry writes, it is the care with which Justice Ginsburg decides when to disagree and the precision with which she expresses disagreement that bespeaks the respect for her colleagues and the institutions that others sometimes honor only in form. And I'm sorry, I think Larry had a longer version that I don't seem to have. I'm sorry. All right. Very good.
Well, I'm very, very glad that Larry made that point, because if I were to dissent every time I disagree with my colleagues, I would never sleep.
Herring versus United States, 2009, another dissent. Nancy Gertner wrote about this one, and she said, Justice Ginsburg, meeting the majority's decisions on its own terms, deconstructed cost-benefit analysis. Maple versus Thomas, 2012, Carol Steiker writes, what makes Justice Ginsburg's opinion for the court in Maples noteworthy, and what made it controversial among the justices to the extent that it was Justice Ginsburg's explicit connection of the breakdown of representation in Corey Maples' case to Alabama's system of capital representation for indigent defendants. Coleman versus Court of Appeals of Maryland, also 2012. This is a dissent. Julie Sook wrote about this one. And Julie says, according to Justice Ginsburg's account, workplace discrimination against women also includes actions that well-meaning and rational employers adopt to avoid the real costs of pregnancy and child-rearing. Congress can thus combat discrimination by making it as expensive to employ men as it is to employ women. And the last one is NFIB versus Sebelius, also 2012, also a dissent, Mark Tushnet. And he writes, Justice Ginsburg's dissent in NFIB versus Sebelius gave the Chief Justice a gentle lesson in legal analysis and in the politics of enacting statutes. She gave a more pointed lesson in economics to the colleagues who found the Affordable Care Act an unconstitutional exercise of Congress's power to regulate commerce among the several states. These essays are given to you in a bound version, which you have. They will also be made available online or in a publication. We're not sure which, but they will be available. And in that sense, we hope to be giving you a bouquet for the bouquet that you have given us. Justice Ginsburg, it is an extraordinary honor to be in your presence, and we celebrate your 20 years on the United States Supreme Court thus far.
Please be seated. It's enough. Thank you. Martha, may I say I've been to many law schools, and I've got many glass figures and plaques. I have never gotten anything that I will value more than this essay collection.
Oh,
so I thank you.
Thank you. Thank you so much. Thank you so much. And thank you for taking very good care of your health. So, thank you all. Thank you all.